a small presentation which tries to capture what we're trying to say.
So should I?
Either way, Shika, maybe I think I'll start and then maybe you can take over.
Sure.
Right. So that's the a small presentation on the SEBI's proposition. So we'll just talk about first what exactly is the problem statement. The problem statement basically is that as companies undergoing resolution are acquired, I think the whole purpose of CRP is that companies will get acquired. As we've seen, very large listed entities have also gone into CRP. SEBI has presented some data as well about number of companies which have undergone CRP. And we noticed that out of nearly 100 odd companies, in most of the cases of resolution, the equity capital is reduced to zero value. Promoters' equity capital obviously gets reduced to zero value, but as the treatment given by an acquirer cannot be different for different classes of shareholders. Equity itself is a class, and I'm sure everyone understands that when it comes to priorities of Section 53, that's the core of insolvency law. There's no question of tinkering with that Section 53 principle. So equity shareholders are the last in the queue. And equity is equity. So no matter who is the person who's putting in equity, whether it's promoter or a minority shareholder, equity is equity. And therefore, all the equity holders typically get reduced to a zero value, which means the share capital gets completely written off. And then the acquirer comes mostly either maybe continuing with the same corporate debtor as legal entity, or might probably propose a merger of the corporate debtor into some of the entities of the acquirer. And share capital is then allotted to the acquirers, whatever preferred investors. Sometimes the acquirer is a special purpose vehicle, therefore the multiple investors who come in. Sometimes the acquirer is an asset reconstruction company which might have issued, say, security receipts. So money might be coming into the acquirer from different sources, but invariably the existing equity holders, in more cases than not, and the bulk of the cases, 75% of cases, the capital of the existing holders gets completely eroded. Now the question therefore is, therefore automatically the company becomes delisted because shares are completely written off. That leads to delisting of the company. If the company that was undergoing resolution was a listed company, one of the basic principles of listing is to provide assurance to minority that before the company goes for delisting, there is a certain, minimum threshold acquisition that has to be done by the promoters, and there has to be minimum price to be paid to the outgoing shareholders as well. So resolution by itself mostly leads to delisting as equity capital suffers a write-off. And if delisting is a necessary consequence, or let's say most common consequence of a resolution process, then why will it not be required to follow the delisting regulations? Delisting regulations currently provide, as it stands, it provides a carve out to CRP. So it provides an exemption that delisting regulations will not be applicable where the delisting happens as a part of resolution plan, where either exit opportunity is provided, or it goes to say either the company provides exit opportunity, in which case the price cannot be less than the price paid to promoter, or it is a part of the resolution process itself. So that would mean, to the extent a delisting happens as a part of resolution plan, then the delisting regulations as it stands today will not be applicable. And that's exactly where the problem is, because while promoters' money gets written off, I don't think there's anybody shedding tears for promoters' money getting lost. But they were the promoters. They've enjoyed the company for a good number of years. More often than not, the company gets into sickness. Promoters don't, as such, become sick, so to say. Promoters might have avenues of, finding other business opportunities. Very often, the business itself might have been hived off into different other profitable entities, etc. Those are issues that we don't need to get into. But the question is that we are not necessarily lamenting the fact that promoters' money has been written off. But when minority shareholders are nowhere in the process, they are not a part of the resolution process at all. Their concurrence by way of any resolution is not taken. They are not members of the committee of creditors. They are nowhere in the scene. And suddenly you come to know that the company has now become zero and that business has been acquired by somebody else. I was a so-called owner of the business. I was a minority owner of the business. Now the business has gone completely off my hands into the hands of a new acquirer where I have absolutely no say whatsoever. So in terms of the underlying philosophy of SEBI's concept paper, it's quite understandable. How can you completely shut the gates for minority shareholders without allowing the minority at least some way to participate in the in the acquisition process? That's the beginning point. Now, what is SEBI actually proposing is that if for a minute that new acquirer, the acquirer who's acquiring the business, we call it the new corporate debtor. New corporate debtor doesn't mean a change of legal entity. Quite likely it will not be a change of legal entity because typically the existing legal entity will be continued. Though as a part of resolution plan, the existing liabilities are subjected to haircuts, subjected to a write down. But the corporate debtor quite often will continue because people will try to take benefit of accumulated losses. There are carve outs from minimum alternative taxes as well. So that's a tax issue. We don't need to get in that. But quite likely the legal entity will be continued. And there, if we refer to this company post acquisition as the new corporate debtor, SEBI says that you need to provide at least 25% of the equity capital, whatever be the equity capital of the new corporate debtor, at least 25% of that equity capital you need to provide to the minority. When I'm using the word minority, I'm actually should be saying non-public shareholders. Public shareholders. By which I mean exclude the promoters, excluding the promoters, excluding so what all can be counted as public shareholders. Those public shareholders need to be given at least a 25% participation in the equity of the new corporate debtor. Now that would actually mean what? That those minority shareholders will actually have to put in further money. Now on a priori basis, one could probably once again say, I have burnt my money already. Now the company, the acquirer is asking me to put a part of the acquisition price as further investment. So why would somebody be willing to put in money into a case which has already lost money? But that's a question of, let's say, the decision of the minority shareholders. I think there's a very good rationale for minority shareholders willing to put in money because the acquirer has come. The acquirer is obviously getting the business for very good value. Mostly, I'm sure you understand that acquisitions happen at a very attractive value. And sure enough, the acquirer is putting whatever, let's say 100 crores. He's not hoping to lose his 100 crores. He's hoping to get a very good rate of return on that 100 crores. So assuming the acquirer is putting 100 crores, then a part of that 100 crores should come from by giving minority shareholders an option. A part of that money should come from minority shareholders. And therefore, it's a participative acquisition. By participative acquisition, what I mean is 75% money comes from the acquirer, 25% money, up to 25% money comes from the minority shareholders. So the minority shareholders got a right to participate in the acquirer by way of getting shares in the new CD. Now, if we give this offer, let's examine three situations. The company does not want to give the offer at all. It doesn't want to give offer to the minority shareholders at all. And somebody says that I will contribute entire 100%, 100 crores. I will not care for the rights of the minority shareholders at all. That's one situation. In that case, SEBI says, in that case, the carve out or the exemption from delisting regulations will not be applicable. That would mean you need to comply with delisting regulations. The moment I say you need to comply with delisting regulations, what it actually means is that I will have to offer a minimum offer price to buy the shares from minority shareholders. And the computation of that offer price is almost following the SAST takeover norms. So there'll be a substantial extent of payment to be done to buy the shares of minority shareholders to go for the delisting route. And therefore, the exemption from delisting regulations currently applicable will be made conditional upon the company giving the 25% right of participation to the minority shareholders as is a part of this proposal. So the option of not giving this 25% doesn't therefore remain, because in that case, you anyway have to follow the delisting regulations. That's one situation. Second situation, I give offer to the minority shareholders, and let's say I give the option to participate up to 25%. However, investors, they don't come forward. Then the investors don't take my offer, and say investors take my offer to the extent of 2% only. 25% I offered, they take only 2%. The remaining 23% is not taken. Then SEBI says that if at all you get interest of minority shareholders to the extent of less than 5%, 25% is what I offered. If I get less than 5%, in that case, the offer fails. And in that case, the company will go for delisting without having to abide by the conditions of delisting. That would mean I can go for delisting. No damage done. I don't have to make any offer for buying public shareholders, etc. Therefore, I can go for delisting straight away. Third question, can the acquirer, for example, SEBI says you need to offer 25%. Can the acquirer, for example, offer, say, 51% shares to minority shareholders and say, I will offer you 51% of the capital of the acquirer? Now, that's actually not envisaged in the SEBI discussion paper, because it's talking about 25% only, which means 75% shares are still put in by the acquirer. 25% capital comes from the minority. We are therefore able to address concerns of section 29A. We are also, now, if you follow this process, then the company will continue its listing. The company will not lose its listing status if you have given this minimum offer of 25%. And if you, like I said, if you don't give the offer, in that case, the company becomes delisted, in which case the company will have to comply with the delisting conditions. So that is, in a sense, the proposal from SEBI. If you were to quickly run through some of the situation, some of the situation, we'll probably be able to see that in most of the cases where listed companies have gone for, right hand side, you'll be able to see listed companies. Where listed companies have gone for CIRP, it's only a small part. You can see this is the part where companies have continued with the listing. Either a large part of companies end up into delisting, a substantial chunk is still undergoing CIRP, so we don't know. But mostly, as you can see, most of the companies actually opt for delisting. That's what is happening currently. Now, that's not a happy situation, because minority shareholders completely are erased out of existence, and therefore that's not what SEBI prefers. So the proposals in the consultation paper are, this proposal of course is applicable only where the company undergoing CIRP is a listed company. It's applicable to listed companies only. If the company in question is unlisted company, the whole question doesn't arise. There we don't need to care for listing regulations at all. If it's a listed company, it is mandatory to offer 25% to the minority shareholders, up to 25%, and the minimum level of acceptance is 5%. Now, 25% is 25% of what? 25% of the equity capital as proposed in the resolution plan. So that would mean resolution plan. To give an example, supposing a target company is acquired for a total, let's say resolution value of say rupees 500 crores. The acquirer agrees to pay rupees 500. The existing asset base of claims might be 5,000 crores. The acquirer agrees to pay 500 crores. And that 500 crores is split into, let's say, equity capital 200, and let's say debt of 300 crores. 200 crores of equity, 300 crores of debt. Now, if the 200 crores is the value of equity in the so-called new corporate debtor, then of this 200 crores, at least 25%, meaning 50 crores will be offered to minority. The remaining 150 can be contributed by the persons who are willing to invest in the equity capital. That is the so-called, let's say, acquirers persons. They can invest in the capital of the new corporate debtor. The only question which still remains is that in order to continue listing, there is something called minimum public holding norms, MPH norms. So the question will only be, how will the minimum public holding norms be adhered to in that case? That's a matter of detail, because assuming you made offer for 25%, but only 5% comes, then the 95% of the capital is not held by public. And possibly there'll be a way to either make an offer for sale or to comply with the MPH condition within a given time, It's quite usual for SEBI to allow time for achieving minimum public holding. So that's something that is in the details. And therefore, let's park it for discussion as of now. But the basic idea is that of the 200 crores worth of equity capital, 25% will be held to the minority, will be offered to minority shareholders. Remaining can come from the acquirer. And if we don't get 5% response from the minority, in that case, the company will go for delisting. It will be exempt in that case, but exempt only subject to that condition. So the good part is that we have not tinkered with the priorities of Section 53. We have not created classes among the equity holders. The only question will be that will the existing promoters, because existing promoters will now become public. As there is a new acquirer, change of control is happening. The existing promoters will become public. So whether these existing promoters also may participate in equity as public holders, that's also a question that we flag for discussion. And whether there is any Section 29A issue. Section 29A doesn't mean the erstwhile promoters cannot hold even 1% share of the company. But question is, can the existing promoters still be participating? We flag for discussion. And we were talking about the 25% holding. So we've actually said that this is 25% because now there is so I think the meaning of public shareholders to whom the offer will have to be given is laid down in the regulations. It is as this way. The public equity shareholders and negative list is provided. That would mean promoters are negative listed. Promoters are not captured in the list of public holders at all. Shares held by associated companies are negative listed. Family members of promoters, no. Trust managed by promoters, no. Directors and KMPs, no. And public shareholder representing a member on board, meaning a board member, with obviously not. So the question basically is when talking about public holding, we are excluding each of these negative listed categories. And question once again will be when we decide to make an offer of this additional or this 50 crores to the public holders, how do you make this offer? How much of the offer is made to who? So regulation, the SEBI's proposal says that the offer will be made on a proportional basis to the public shareholders. What does proportional basis mean? That would mean the proportion, we need to offer 25% only. So we're talking about 20, but let's say the proportion of the public holders in the existing capital was 60%. Assuming the proportion of public capital was 60%, and we are now proposing to give 25% only. So it will be 25 by 60 multiplied by the existing holding. That's the kind of offer that you need to give. And then wait for the public to actually show interest in taking this holding. So that's the proposal. Another question that comes is when we are offering these shares to the public holders, at what price will we offer the shares? And the proposal says that the shares will be offered at the same price at which they are being offered to the so-called investors in the new CD. That would mean the equity holders in the new CD, the acquirer, the resolution applicant, at whatever price the shares are being taken by the resolution applicant, at the same price will give the shares to the minority or the public holders as well. Now, is there a possibility of some overvaluation of shares whereby the shares are overvalued and therefore the public is asked to put in a substantial amount of money in the equity of the new CD? Now, while the Income Tax Act, Section 56 to 7B, which talks about shares of a company being priced at more than fair value, in which case the differential being taken as other income of the company, while that provision is not applicable. But in our view, this will be still bound by the provisions of Companies Act. Section 62 will be applicable here. This is not exactly a rights issue because shares are not being offered on proportional basis to all the shareholders. And therefore, there will be question of shares being offered at fair value. So the question is it possible to sort of play with the fair value and therefore offer the shares to minority shareholders at an inflated price? Frankly, we don't see that possibility because we are talking about a company under insolvency, which has now been acquired. And the share capital of that company already on acquisition seeing an appreciation, and therefore the fair value of shares being more than the par value. I don't think that is at all fair or reasonable. If at all somebody tries to play with the value of shares and tries to put a share premium or a valuation higher than the par value, to my mind, the adjudicating authority, while approving the resolution plan, can definitely put a question on the price at which shares are being offered. Because unless one plays with the cash flows after acquisition, but that's completely a story, because all this while the company was an entity under insolvency, merely because the entity is now coming out of insolvency, its shares seeing an appreciation in value, we don't see a chance of, that possibility being there. However, that is still a concern. The concerns therefore would basically be pricing and whether shareholders will actually find this acceptable. And that apart, the concern will be that in many cases, resolutions are quite complicated, because in many cases, you'll find resolution plan says the corporate debtor will be acquired and then different units will be transferred into different entities. So the CD will be split into multiple entities immediately upon acquisition. And those different units will become different undertakings to different companies. So if that is the situation, then in which company are we talking about giving the shares to the minority shareholders? Because the company undergoes a process of merger or demerger immediately upon resolution plan is a part of resolution plan itself. We are talking about shares being given in which company. So that is a challenge. Sometimes the challenges also could be that the CD is acquired in a special purpose vehicle in which various investors come who become multiple investors. In all of these situations, issue is we are talking about giving shares in which entity. One may also try to manipulate and play with the number of shares to be offered to the minority shareholders by minimizing the equity capital component. If 500 crores is resolution value, nothing stops the acquirer from downsizing the equity by increasing the debt. One could say of the 500 crores, I will be putting only 50 crores as equity and the remaining 450 crores will be debt. Though that's a very unreasonable number, because then we're talking about a debt to equity ratio of 9:1, which is extremely unreasonable. But in resolution plans currently, those kinds of, plays are being done. So if somebody wants to play with the equity number and make it extremely small so as to minimize public participation, that is possible though. But I think we are still constrained by same thing, that if ultimately the public doesn't participate in the process of acquiring the equity, the company will undergo delisting. Though the company doesn't have to make an open offer, but that, the issue, therefore, the concern could therefore be that will the resolution applicant try to manipulate the extent of equity in the resolution price so as to make the public offer, the offer to minority shareholders, extremely unattractive, and therefore rule out the minority participation. And thereby the company goes for delisting without complying with delisting regulations. Is that a play, or is that a concern that you all have? And I'm sure there are other concerns that you all have, but let me stop here. First, I'll ask my colleague Shikhar to maybe take this discussion a bit forward. But essentially, we'll all love to hear from you to get your concerns on the SEBI's proposals, so that Nitika from ICICI IPA can assimilate our concerns or feedback to be able to take the discussion forward. Shikha, whatever you would like to add here. I'll stop sharing.
Yes.
So if you want, you can maybe start
No,
sharing.
sir, not required. You've covered all the points. Just the point on MPS, that probably SCRR already provides a timeline of say 3 years to get it up to 25% in case of resolution plans, and 12 months to take it up to 10%. So that is already there. I think that will be taken care of. Just to point out the concerns, first of all, we need to discuss here whether this proposal is sufficient for safeguarding the interest of public shareholders as SEBI wants to. Number one. Second, whether the requirement of putting in additional consideration is okay. Thirdly, whether this is a feasible idea for resolution applicants who would want the company to be delisted and to bring the company totally under its control. Then it's the proposal basically want to impose this mandatory offer on the RA. So will it actually help resolutions, and those from those fronts we need to discuss today. So we would want to invite comments from
Maybe I think
the
the first thing
participants.
we can start with, Shika, and I think Vikramji has already raised his hand. And I'm sure there might be other questions as well that people have, but let's maybe start with first thing. This proposal to offer shares in the new corporate debtor to minority will be a part of the resolution plan.
Correct.
Therefore, it's not as if this entire offer to minority holders has to be done during the 6 months or 9 months time of CRP. It's a part of resolution plan. What would that mean? That would mean the resolution applicant proposes to offer 25% shares to the minority holders, which means once the resolution plan is confirmed, then within a certain timeline, the timeline for making the public offer also perhaps has to come. So that may be, I think, point to flag to say that there needs to be a timeline within which the shares will be offered. But the resolution applicant will be required to offer shares to minority holders within a specific time post confirmation of resolution plan. So it's not like we are keeping the resolution plan on hold till the time the minority offer is done. It's a part of the implementation of resolution plan and not a part of the resolution process itself. It's a part of the implementation. And therefore, is there any concern or question about we already have a problem of delays, and I mean, delays are for multiple reasons. So are we sort of dragging the resolution process and making it more prone to delays, if at all? So is there a concern at all? Vikramji, you've raised your hand, maybe you or others. And if you have others have other questions as well, maybe we can discuss those as well. But let's hear Vikramji first.
So thank you, Vinodji, and thank you for the excellent presentation. I'm audible, Vinodji?
You are.
Yes, sir, you are.
Yeah, okay. So, I have multiple objections to this discussion paper. And my understanding is that the intent of SEBI is very noble, but it would end up doing more damage than good. Because the point is that we already know that there is a dearth of resolution applicants in the market. And the Honorable NCLAT has already held in the Binani Cements case that the first order objective is resolution. So the objective of IBC is first resolution, and then the other objectives will come into play. Now, the point is, if suppose I am the applicant and my first interest is to revive the company, then only I am interested in any listing or delisting. So my point is, I'm not interested in running as a listed entity because the company is in a loss. I want to focus all the attention to reviving the company. And once the entity has been revived, then at a fair value, I would like to come out with a public issue or whatever issue I would like to come in. Because at this stage, I'm actually, issuing the shares to the public holders at a throwaway price. Because I, as a successful applicant, is actually acquiring the entity through a lot of, value additions I'm doing, say the ability to bring debt. It is not available to everyone. Say Tata is acquiring a company, so the Tatas are able to raise debt, and that's the reason why they are a successful resolution applicant. Number two, they would be bringing in a lot of capital in reviving the company. So we are actually not valuing all the other factors. We are simply putting in the price at which Tata is acquiring the equity. There are a lot of other value additions are happening, which is going ignored. So the point is that it should be first and foremost is the applicant should decide whether it wants to run the company as a listed entity or as a non-listed entity. And if the entity is, the RA believes that it wants to run a company as a listed entity, then only all these provisions should apply. Otherwise, the application of this provision does not come into picture. That is the first point. Second point is, On page number 7 of the discussion paper, they have given a table wherein they have very clearly stated that the promoters shall also be classified as a non-promoters. So the promoters also become non-promoters. Technically, they are also public now. So 25% equity is being offered to the promoters and non-promoters. I call it as one group. No, why I say so? My point is that if you see in the table, if 25% is already held by the promoters and public, then further equity to be offered to the serial number 2 as stated in the table. So basically, the point is you are offering the 25% equity to the promoters and public at large, and both the entities are entitled to subscribe the 25% equity. At least 5% equity has to be subscribed by the public, then only it stays as a listed entity. Otherwise, it does not stay as a listed entity. Is my understanding correct or wrong in this point?
Just one point, Vinod sir. Just one point, Vinod sir. I think there is a disconnect. There is a disconnect in the provision of the proposal versus what they are providing in the table. Because in the provision of the framework proposal, they are saying that public shareholders won't include promoter and promoter group. On the other hand, in the tabular illustration which Vikram sir is pointing out, they are kind of including that, say, whatever percentage the promoter holds in that 25%. So I think
not
that
necessarily.
is the...
If we read it properly, it might be possible to reconcile that, because not every acquisition results into 100% write-off of equity. Assume a resolution says that equity shareholders will be reduced to the extent of 25%. The existing equity, if it's 10 rupees, it becomes 2.5. So that would mean we already have 25% equity. Then the question of offering any, so I think that's the first row of the table where we're saying if the equities have been depleted to the extent of 25%, that would mean we did a 75% write down, 25% capital anyway is now public, including the erstwhile promoters. Because promoters are also not necessarily being reduced to zero. If I am not reducing the minority shareholders to zero, I cannot reduce promoters also to zero. So if everyone is reduced to 25% value, then there is no need to make any offer to the so-called public holders. That public holders actually excludes promoters. So promoters are now reclassified as public, but that is possible. That's true. Only in cases where the equity is not reduced to zero value. Shikha, I hope therefore that...
No, I think you are right, Vinodji. I got your point. So I stand corrected here.
That's okay. The table is a matter of detail.
So I stand corrected.
But Vikramji is vehemently opposed to the very idea of offering the shares to minority. So I can see that Rajkamalji also has raised
points, one or two quick points before the other speakers come into picture. So the point is that, say, as you gave the example of the category 2 cases where, 2% equity is actually bought by the minority shareholders. So eventually the company will be delisted and that 2% equity will be returned back to the minority shareholders. That is a correct understanding?
Absolutely,
okay.
Absolutely.
Now, what happens if there is a default in implementation of the plan? Suppose 5% equity has been contributed by the public minority shareholders. And then the plan, there is a default. And eventually, the implementation gets impacted because that is very common these days. That is not covered in the discussion paper.
That's a very fair point. I think Nitika should, Nitika, I hope you can flag this. A very important point is mentioned.
Yes,
becomes a very important point. It's a very significant point.
The third point is that this public shareholding, this offer will be made post order of the NCLT or prior to the order of NCLT. Which stage this will happen?
In my view, it's a part of implementation. Therefore, it's after the order of NCLT, because before the order of NCLT, the question of making an offer doesn't arise.
Correct.
But I think there are at least now Vikramji has made several significant points, but let's maybe pick up the first point, because Vikramji seems to be opposed to the idea of offering shares to minority altogether. And we will like to hear Rajkamalji as well, but let's maybe first, if somebody else has views on that, because what Vikramji says is that the acquirer is getting the shares, as he mentioned, at throwaway price. So I think the question would therefore be, the acquirer is getting shares at throwaway price. Why would he not want, why would he frown upon giving the same throwaway price to the minority?
My objection is because suppose I am raising 450 crores as debt and 50 crores equity, this 450 crores of debt is being raised because of my own goodwill in the market.
In every listed company, that's what happens. I mean, the promoters have their goodwill, they are able to raise debt.
And suppose I have to invest 2,000 crores in reviving the company.
Yeah, what you spend, I mean, other than the resolution money, the initial resolution money, whatever further capital investments are required for, I mean, reviving the company, for growing the company, etc., all of that will be a part of the capital structure. So as the company expands capital, there'll be a process of rights entitlement, there'll be a process of preferential issue. This 25% that is offered to minority might eventually become, who knows, might become 2.5%. With the company's capital will grow over time. But that is the usual process of every listed company. In every listed company, there is a promoter. The rest of the minority holders are getting their valuation because of the stake of the promoters. Promoters play a very important part. So here, the resolution applicant's efforts and the resolution applicant's, let's say, endeavor to revive the company is unquestionable. The only thing is that if he is able to see a value in that, should a part of that value not be spread to the minority as well? I mean, that's probably what is SEBI as a regulator might have thought from this perspective. Vikramji seems opposed to that, but Rajkamalji, do you want, and Mr. Anil Kati also has raised his hand. So do you want to maybe first discuss on this point? Is it something which is fundamentally objectionable, mandatorily giving an offer to minority, or are we fundamentally agreeable to the proposition? Thereafter, question of details will anyway be settled. Whoever wants to speak first, Rajkamalji or Anil Katia ji, and there are several other people raising hands. Rajkamalji, आप mute पे है.
I wanted to add another dimension. Suppose in the regional plan there is the out of the total 500 crores of rupees, there are 4 category of investment. Say one is equity, one is convertible preference shares or redeemable preference shares, or maybe convertible debenture or optionally convertible debentures, and different things are there. So whether the SEBI thinks of giving offer in all the 3 categories wherever the equity is to be converted, or it will be only for the equity, that is not clear in the proposal. So that if it is the structured things are there, so I think that point is to be added in the SEBI.
So Rajkamalji is mentioning sort of a possibility of adding further detail, because SEBI is obviously expecting only the equity to be offered, not the rest of the instruments. The question of offering any other instrument doesn't rise to my view. But well, if the resolution applicant brings, for example, say convertible shares have an inherent conversion option. Resolution applicant may get, for example, warrants. Or for that matter, if resolution applicant for whatever other reasons wants to make this public offer extremely unattractive and therefore wants to minimize the equity component by, let's say, blowing up the debt component. What stops the resolution applicant from saying that out of 500 crores, only 5 crores will be equity and 495 crores will be rest of the capital structure? Nothing stops him from, I mean,
so in
exaggerating.
Exaggerating
the rest of the components of capital structure so as to minimize the equity and therefore minimize the public offer and therefore make the public completely irrelevant in the process. But if that is what the resolution applicant does, then to my mind, adjudicating authority while approving the plan may challenge it for unfairness. Because essential principle of every resolution plan, it has to be fair to all the stakeholders. So I think what SEBI's consultation does is to make the minority shareholders a stakeholder in the resolution process. And therefore, fairness of the resolution to the minority holders becomes important. So it might be questioned on that ground, but that is for the adjudicating bodies to exercise their jurisprudence. Anilji, would you want to say on the, I mean, do you have any basic objection to the process, or you are basically aligned, but there might be questions of detail?
No, I am absolutely aligned with what SEBI has proposed. And I think if any resolution applicant believes that the company has continued to be listed, obviously they have to comply with what is the SEBI's normal norms of a listed entity. I don't see anything wrong being done by SEBI here. In fact, SEBI is enabling the process by giving you an opportunity to raise the public shareholding in stages if you can't do it in one go. That's one. Second, I really don't see that there is a pricing issue here. I think we need to call it offering of a new company at par. Simple. Keep it simple. So everybody who is coming at par at the start of the process. The resolution applicant has paid equity according to the value of the company or infused money according to the value of the company. So he is giving part of the value and part of the equity to the shareholders in proportion to what he is offering. So I really don't see anything wrong in it. I think it is an enabling process for a listed entity. And I think it is quite required. If somebody doesn't want to go through this cumbersome process, he can choose to be a delisted entity. That's all. Thank you.
And follow the delisting regulations, which will be even more cumbersome. But there you have to follow the SAST process.
Yes, if he or she believes that he doesn't want to go through the rigors of raising money, offering it to the minority shareholders, I would say let's look at it differently. I don't see this as a benefit being extended to minority shareholders. I see more of it as a listing requirement.
Well, it is of course added. It will be coming as a part of the listing regulations.
Yes, and SEBI is bound to regulate that. SEBI is bound to have that discipline in place to prevent any rigging in the markets. They have to have some kind of mechanism in place which they can monitor then, isn't it? Thank you.
If you ask me, I'm completely aligned when I find that this is what is appropriately the regulators. I mean, anybody who is coming from securities regulation, their concern is more from minority shareholders' point of view. And there is no doubt that minority shareholders have been given a completely, they completely nil role in the entire process of resolution. Therefore, at least ensuring that they are able to put in money and be a part of the future value accretion.
Yeah, it's an enabling mechanism on both
provision.
sides, from the RA's perspective as well as minority shareholders' perspective.
And for the RA, he
RA
gets 25%.
is able to raise capital.
It's true. He's able to get 25% money from external sources.
Yes, what is wrong with that? So you are enabling both sides to come and play the new entity, which is being revived, rescued, resurrected, Right. So I don't see anything wrong, and I don't see anything wrong if the company ends up in liquidation thereafter. The minority shareholders chose to participate in the equity. They took the risk. Now, if the company ends up in liquidation, so be it.
That is a little difficult, Anilji. I think that's a little difficult situation because if the resolution plan is not adhered to, and therefore for breach of resolution plan, the company ends up in liquidation. So that, I mean, the damage for that is going to minority holders who put in additional money, and thereafter the company has to face liquidation. And therefore, once again,
they see, like they assess any draft red herring prospectus, they have to assess this investment. Equity investments always carries risk. So this is a risk in a company being restructured any which way.
Maybe offer document थोड़ा और bold में लिखना पड़ेगा that you are investing in a company which has undergone a resolution, तो थोड़ा और सोच के लगाइए. But on the fundamental acceptability or advisability of this proposal, we heard some of the speakers already. Others, Brijesh ji, Praveen ji, Amog, Mahajan ji. Do you want to contribute on the basic idea itself? If you want to, then kindly do.
Sir, yes, sir. This is CS Amog Mahajan. I have basically two questions. Like, it seems like the SEBI is forcing for lease to continue the company, which is to continue for a listing through this regulation. It looks like that only. And the fundamental question is why is the whole law is basically IPC. It's related to insolvency. And across the world, there is no example, at least as per my knowledge, where the insolvent person will have any say in the insolvency process. So that where the SEBI is trying to create a picture where the shareholders of that company, listed company, or technically insolvent, are also having some say in the process. And second, if the option is there only for, why option is only for listed companies, minority shareholder? Because what about unlisted public, or even in case of a private, whether it will stand with Article 14, equality? Because Companies Act per se do not make any difference between these kind of entities. So whether the SEBI has itself an jurisdiction over creating a law, or it should be the completely prerogative of a parliament only. Hello.
Interesting question though, but I think from point of view of jurisdiction, SEBI has the power to regulate listed entities, and SEBI will come by way of regulating listed entities only. SEBI will not tinker with insolvency law. SEBI will not make any changes in CRP regulations. SEBI will make changes in listing regulations. Listing regulations currently, in delisting regulations, there is an exemption from companies having to adhere to delisting regulations if it is being revived through a resolution plan. That exemption from delisting regulations will be made conditional upon this proposal being adhered to. That would mean if the company doesn't want to adhere to this 25% minimum offer, in that case, the company has to follow the delisting regulations, which means the minority shareholders will have to be acquired by paying the price as per SAST regulations. I think that damage will be much more than undergoing through. I memean, that's a question of choice for the applicant, but to them, that will be a bigger damage. But let's hear this. Pravinji, you want to speak on this issue?
Sir, I am totally against such provisions. See, the shareholder has put on money, he has put in a risky capital. He is well aware that this share capital is risky. When the 10 rupee share can go to 1000 rupee, it can go to zero also. So where is the question of having a minor right for the minority shareholder or mercy for the minority shareholder? That is my thinking. Second thing, if suppose as a promoter, if I buy a plot or something, if you say that seller should have a right in that plot, suppose I buy a 10 crore rupee flat in a Bombay, and tomorrow I am told that one room should be reserved for the previous seller. Why should office tomorrow of say 1000 square feet and that 5 crore rupee? I should keep something for the previous shareholder or previous seller who has lost the money. When the company has lost the money, everybody, all shareholders have lost the money. The promoters have lost, the public has lost, everybody has lost the money. Where is the need of the any new incoming buyer to keep something for the old shareholder? He is nothing. And many cases I have seen the way the previous paid up capital was 10 crore. The value for the shareholder is already zero. There is no money left at the creditors level. Forget the shareholders level. And why should I keep them? Why should I be made to run through the additional process of delisting? When at the first level, 53(1)(a) level or B level, the entire money is exhausted. The bankers itself, the financial caterers itself have a 95% haircut. Where is the value left for the shareholder? And why I should be made run through the entire delisting process? First of all, I am coming for revival. I am a buyer. I should have an upper hand in say. This is my thinking.
Point well made, Pravinji. There are two things we need to understand, just quickly to maybe respond to your points. First of all, the proposal is not asking the resolution applicant to pay anything to the shareholders. Nothing, no question of paying. We are not going away from the Section 53 priorities. We are not proposing to pay anything at all. All we are saying is that whatever be the equity in the new corporate debtor, a part of that equity, that would mean money will be coming from the minority. Money will not be going back to minority. Minority will be asked to put in further money. If they want to buy the shares of the new corporate debtor, they pay further money and buy the shares. It's not as if the acquirer is paying money. But on the other question which you said, why would promoters and minority shareholders be treated differently? And why not treat the two of them at par? And therefore, if promoters have lost value, minority also has lost value. I think while the point on a technical ground, the point is okay, equity is equity, and therefore promoters equity and minority equity is not different. But we need to realize that in the way the companies are run, the payoffs to promoters and the payoff to minority is not the same. And I hope all of us, as at least professionals, we all realize that rarely do promoters actually suffer a loss of value. It's only the minority whose values are lost. That's something that is a practical, ironical reality which we all appreciate. There's no way to either prove or disprove that, but I think we can all feel it if we want to agree on that. But nevertheless,
Vinodji, one quick point. The moot question is whether this will encourage the RAs to come or it will discourage the RAs to come. That is the moot question.
So what you said, the RAs will be discouraged merely because the RA is required to offer 25% to the minority holders. You think the RA will feel that his control is diluted and therefore he will be
So the point
discouraged from.
is, if suppose you discourage even one RA, then you are actually, increasing one more liquidation than the resolution.
That is very completely, that's completely agreeable that even if you set back one resolution applicant, you've done value destruction. So the question therefore is, are we as professionals, are we thinking, are we sensing that this need for the resolution applicants to put in some part of the equity for the minority holders, that would dissuade or discourage or demotivate resolution? Is that the point
So
that
my point
you are
is,
making?
Vinodji, my basic point is, are you giving the importance to minority shareholders above the resolution of the company?
Surely not. There's no question of,
So the point is,
the
the
company
premise
doesn't
of
survive.
IPC, so the premise of IPC is resolution.
Absolutely
Now,
correct.
if suppose you are giving priority to the interest of a minority shareholder at the cost of resolution, then you are doing more damage than you are doing, service.
So let's place this question. Do we see a conflict between resolution itself and offering a certain minimum stake to minority? Are we saying either of these, ya to ye rahega, ya to ye rahega? But if minority is given the stake, then the company will not dissolve at all, or resolution applicants will not come at all. Are we able to see a basic conflict between the two? Or is it possible that the two can coexist? The company may be revived and minority itself may also have its. Kashi Vishwanathan ji would probably want to say something, but yeah, Vikram ji, I think you have made the point, but yes, sir.
First thing is, will the COC agree? Will the COC agree for waiting for the money to come after a certain period of time? That's a basic question which needs to be answered. For example, if the loan is somewhere around 100 crores and you are saying, I'm going to make an upfront payment of something like this in a staggered manner, and then waiting for some money to come at a later point of time to be paid back to him, will he agree to it? On such an eventuality, I'm going to give you this money. Will a COC member agree?
That's a very fair point. And that's a point that we need to flag for SEBI's attention. That even if we ask for a minimum public offer, the question is the timing of the offer, because the COC would need certainty. And if at all this public offer fails, then the resolution applicant has to be still ready to pay the remaining 25%. Because if 25% is not taken, the resolution applicant therefore has to be prepared to put in the remaining amount. So CSC has to be given a certainty of payment, and that too within a time-bound manner. The question of waiting for a staggered offer to public and therefore money coming from public, etc., that is certainly one issue. I think we'll need to flag it. It's just a discussion paper still. It's not like SEBI has come with a resolution, but very important point that you made.
Second point.
Sir, one more question. If the foreign buyers come and buy the company and don't want any equity here in India, he want 100% his own, then he will have to go through the entire delisting process.
Which is even today true, Pravinji. If there's a listed company and a foreign acquirer wants to buy the company out, so take it for
buy the
delisting.
company out. If he is going for delisting, then he need not offer anything. But if he is buying under insolvency, then he will have to first run the entire delisting process.
In a listed company, if a foreign acquirer or any acquirer for that matter comes and wants to delist the company, he is to mandatorily take it to the delisting regulations.
But then today he is allowed to delist the company without any procedure.
No, I think delisting is mandatory. If listed
delisting,
company,
but without any procedure under IBC.
Without
today, I don't have to go through any procedure for delisting. When I'm buying a public listed company under IBC, I don't have to go through any procedure. I have to just say that I will delist the share and write off the 100% share.
No, I have to appoint a merchant banker. I have to give a public offer.
No. Under IBC, I am not supposed to do that.
That's the point I was making, that the company is not under insolvency. The question of IBC, therefore, does not come. We're talking about a normal listed company.
Normal listed company, okay. But for the IBC company, I am coming to revival. I am putting in 100% my capital. Why? I don't need any listing and I don't need any procedure. When there is no value left, why should I do the procedure for that?
So that's precisely what SEBI's point is, that if the listed company is virtually rendered as delisted, unlisted company through the process of resolution, then should the carve out from delisting regulation, currently there's a carve out that you don't need to follow delisting regulation.
Yes.
Should this carve out not be made conditional upon giving a minimum public offer? That's the whole moot point of SEBI. Pravinji, Kashi Vishwanathan ji probably wanted to make some further points. So Kashi ji, would you?
Yes. Sure. Sorry.
No issue, sir. Second thing is, first of all, the time period, for example, the implementation of the plan. The initial period of implementation is very crucial for the revival of this, corporate debtor. Now, if he is not able to do it, it goes into liquidation. Is SEBI looking for an opportunity that after a certain period of time, delisting, 25% minority shareholder should be given an offer? Is it thinking on those lines? Because the level of money being put in is on an upfront basis to take the company into your hands. Then only your other documents with regard to the loan agreements, everything come into your hands. The property comes into your hands. Are we looking for such an opportunity? For example, everything has to be done so that I have the company freehold with regard to assets so that I'm able to utilize it in a proper manner. Probably people might even think of not having loan agreements or running the company on its own with their own equity. In such a situation, what happens? That's a question which needs to be addressed to. Company run on full equity. For example, any loan agreements are there, the assets are being pledged or whatever you call it, however the structures are. Then what happens to that? Because the creditor will never give the documents to me unless and until I give him the full money.
Release of security interest will not happen until the full money is given. I think the point fairly well made. I think you made this point earlier as well. So I think in a reiterated manner, the point basically is that money has to come upfront from the resolution applicant. So I guess the way SEBI might like to frame it is like a minimum public offer post acquisition, as if the entire equity capital will be first put in by the resolution applicant itself, and then a minimum public offer by way of a public offer, as is required under Companies Act by public offer process. A minimum public offer of 25% of the holding of the acquirer will be possibly made, so that the problem of time gap between receiving money from minority holders and the payment to COC, that time gap may be addressed. We can see several hands going up. Mr. Karpattu Subramanian sir,
Yeah.
you want to?
I am Ravichandran K. Sir. Okay.
Oh, hello. Right. I saw a long
Good.
name on screen. How are you, sir? Yeah,
Sir,
good.
absolutely a wonderful presentation. And the premise appears to be, at least to me, that if you would like to have the listed tag post resolution plan sanction, you have to ensure certain minimum level of public float, initially 5%, and later on you have to raise it up to 25%, I think. In fact, recently I have scripted a resolution plan wherein I have preserved the public shareholding and extinguished only the promoter shareholding, whereby the level of holding of the public remains the same, subject only to the new equity that is being created. So we have designed it in such a way that the 5% public float is left. That is, the 25 has become 5 because of the resolution plan and the new equity being pumped in. Even if delisting were to be applicable, it is all about the value of the shares at that point of time. So it is not going to be a costly exercise because the price per share will be decided basis what is possible. Because on every resolution plan, you always find the original secured, let us say secured financial debt itself is probably twice or thrice the sustainable debt. So the sustainable debt, in my opinion, roughly will be equal to the perceived value of the enterprise business assets, etc. So when you look at that way, the value per share will be hardly anything. And therefore, if you want to continue to be a listed entity, I think this proposal, which is already in existence, is slightly modified so that the 53 waterfall giving the last junior most entitled shareholder 0 is able to acquire it instead of receiving it like a gift in this plan which I have made. So therefore, I think it is some modalities have to be worked out. Some difficulties as expressed by the learned professionals here are very, very valid, because I know the timeline issues relating to timelines, the COCs, the money that is supposed to come, the evaluation matrix. probably all of us will be knowing that in the initial 30-day period, how much you are going to pump in out of the money you are agreeable to pump in will give you the more points, brownie points, I can say. So all these things probably SEBI will take consulting, and that is why this consultation paper has come. All of us are entitled to share our thoughts and bring a proper implementable, I think, the paper or regulations. That's all. Thank you.
So, Mr. Ravichandran sir, you are not as such opposed to the idea of the minority participation in the acquisition process, because you said you have gone a step further and offered shares to minority while depleting the entire promoter's capital. That's extremely magnanimous.
Because
Yeah,
we
you're
are
right.
able to actually, kindly permit me, Vinod Kothari ji, that we were in fact able to offer to the financial creditors a share value at a particular price per share with an upside, because anyway, if it is listed with a new efficient management, inefficiency being the premise for the state of affairs, the upside is likely to bring them big rewards without the resolution applicant putting money on the table.
No, I completely see your point. I mean, you rightly mentioned that this proposal might require a whole lot of refinements, whole lot of detailing to make it workable. There are some difficulties which participants have raised. I think that's the whole purpose of flagging it. But on the point of Mr. Ravichandran's point about delisting, and delisting not being a very costly process, to my mind, it might still be, I mean, between offering shares to minority versus taking the company for delisting, to my mind, I think delisting might be relatively costly. And the reason why I say so is because while technically every case of insolvency, financially the equity is reduced to zero value. Because that's when insolvency occurs, when the liabilities are exceeding the assets. That's when we say it's insolvency. Therefore, the equity is technically zero. However, normally we never find the actual stock market valuations of equities to be either zero or close to zero. Valuations are still positive. Probably the shareholders are still hoping that something will happen, and therefore the company will revive. And delisting regulations require us to offer the minimum value as per SAST regulations. SAST regulations in turn look back for 26 weeks, 52 weeks, etc. And therefore, we're talking about a highest of the 4 or 5 different values as per SAST. Therefore, if the acquirer proposes to go for delisting, perhaps he might end up paying a much higher price than offering the shares to minority. So that's just a point in case you would like to maybe consider that. But a lot of other people also are raising hands. Mr. Amok, sir, Hiten Parekh, sir.
Yes, sir. Am I audible?
You are perfectly audible,
sir.
Sir.
Two things that I need to tell you. Before that, even the listing will continue, whatever the past problems of the SEBI, that automatic exemption should take place, because the old promoters must not have complied with a lot of things. That is the one aspect. Then only the listing, the new promoter would like to continue. Otherwise,
that's a washout.
Yeah.
That's there in the law.
No, this has to be directly taken into account. Number one.
There
And
in insolvency law itself.
Like what we are doing is like CIRP expenses we are keeping aside. I'm not saying that in the similar manner, some 10 lakhs, 20 lakhs, 30 lakhs should be kept aside even for the purpose of the minority, even if you are delisting also, assuming that. Because what is happening that minority people are not getting otherwise anything, and because of no fault on their part. So even if they try to just go for a delisting, then there must be some kind of a minimum money that should be given to them. That should be a provision in the IBC so that it will not get a comment. This is my view. I'm just telling you, because I've seen I've also drafted a lot of resolution plan, and people are just saying zero money. So therefore, they are not getting, there is no fault on their part. I agree that the equity value is zero. Secondly, at the same point of time, even Alok Industries, let me put it like that. I'm just giving you a name. At that point of time, what has happened that so many investors have taken the shares at 10 paisa and 15 paisa, and they have taken 1 crore, 2 crore shares. And thereafter, the resolution plan approved and the company continued. There they meant a lot of money. So those kind of the red flags are also required to be taken into account, so that it should not happen that some scrupulous investors may not take the advantage of it. These are the two things which I want to just tell.
Now, I think the question of making any payout to equity, that would probably conflict with Section 53. Section 53 may
appreciate, but when you're going for the Delisting. I'm just not saying that. So
Going for
delisting,
delisting-
thereafter, it will be automatically restricted on that. This is what I'm just
If
mentioning.
you're going for delisting, it's not the company that pays the money, it's the acquirer or the promoter.
Acquirer will pay some money to the
That is-
investors, to the minorities.
Sure. Mr. Brajesh Singh, would you like to speak, sir?
Yeah, sir, actually, let me put in my views because I am involved in some litigation also on behalf of shareholders in NCLAT, and I have spent almost 35 years.
Which resolution professional is not involved in litigation, sir? I think all of us are.
No, actually, I'm
ironical part of life.
I'm representing shareholders actually.
Right.
And I have spent my 35 years career as a company secretary serving the shareholders only. So from my heart, I would like to say that this is a very positive step to safeguard the minority interest, because, you know, they have to be looked upon a different kind of resource for the economy. You know, people create entities, then they invest in the company, then they come out with the public issue to unlock their capital. And they offload their shares in the market, and they claim, I personally know this, that promoters say ki yaar ab listing karao and then you unlock your money. So at that time, you know, retail shareholders put in money and create wealth for the promoters. A recent example I would like to give, there is a case of CG Power. You know, they have taken over the company, which was in totally zero. Promoters committed a lot of frauds, whether committed or not, it's a question of different, you know, but they defrauded the shareholders. But the company, the promoters which took up the company, they did not write off the capital. And they bought the company around at 750 crore rupees. At that time, the market valuation of that company was around 600 or something. Can you believe after 2 years of revival, the market cap of that company is 44,000 crore? And how much wealth that promoter has created for himself, because he acquired share about 53% during the time of when the price was lower. He acquired as per the SEBI regulations for maybe in 40. So although he has created wealth for himself, at the same time he is sharing wealth for the with the minority shareholders. He is not giving from his own pocket to these minority shareholders.
Inclusive prosperity. It's an inclusive process.
Nobody is giving from their own pocket. These are market forces actually. And sure. one of the very creative proposal they created in the resolution framework was, although it was a debt restructuring, not an insolvency proceeding, they gave some shares to the financial creditor also. And later on, after this 2-year period, he exited. He recovered all his dues without any 0% haircut. So market, that doesn't mean that if that person, that financial creditor, that is Standard Chartered Bank, they reward 200 crores. They exited as 200. So they are able to recover money. That's what I'm saying, that this kind of proposal should be looked upon as a wealth creation exercise. Not at that somebody is giving to the shareholder, somebody is not giving to the shareholders. The only weak point today in the system is that shareholders are not organized. If there is some mechanism where you are able to organize these minority shareholders, the time will come that these shareholders can give resolution plans. And the experts are available in the market. You hire the CEO and then they will run the company.
Good idea, but asking, so even employees, I think in some cases have given resolution plans, but otherwise organizing people collectively.
Yeah, because credibility is not there. No? They are not. They have not track record, because you see, Reliance can give any kind of proposal, everybody will accept it.
Sure.
But
Mr.
if some body of shareholders will give, nobody will accept it. So there is a need to institutionalize these kind of things. Maybe later on these things will come. But I am very optimistic and I am very happy that SEBI has brought out this proposal. I am dealing a case where, the capital of minority shareholder was less than 1% of the total admitted claim.
So Brijesh, if there are a couple of other people also wanting to raise, say something. So maybe if we can come back to you in a minute from now.
Sure.
Anuj Jainji.
Yes, thank you, Vinodji, and thanks a lot for organizing this session. It's a wonderful session. My quick take on this is that I don't agree to the concept of having protection for minority shareholders. Because it creates class divide. The operational creditors, unsecured financial creditors in many plans don't have any recourse. So how can we get equity holders to step over them, even if they're a minority? Even operational creditors are minority. There are a couple of Supreme Court judgments which clearly say that minority holders don't have any rights. So that also we need to recognize, because that's law of the land. So I feel, and if at all, for some reason, an option has to be given to minority shareholders, then I feel it needs to be at the resolution plan value, because every resolution plan is converted into the total value of the resolution plan when you submit your Form H or when you do your comparisons with liquidation valuation, irrespective of what capital structure it is proposed. So if at all an option has to be given, then it has to be given at the resolution plan value. So that is my point. I have a limited additional point which is also important from the concept of minority shareholders. If you may permit, may I bring it up, sir? And this is essentially on the fact that a lot of the problems which are getting caused in some of the companies like Alok and all what we discussed is because SEBI has chosen, or government has chosen, to permit trading while the company is in insolvency. I feel the solution to that is that after a company gets into insolvency, maybe 1 month mandatory trading with notice should be allowed, and after that it should be suspended, because unless at that time you don't know who's going to buy the company, so chances of stock manipulation are minimum in the next 1 month of insolvency. But as soon as you get to know who the resolution applicants are, then manipulation starts, and then buying stock at lower price, and then taking it higher, and all of those things start. So I feel there should be suspension of trading during the insolvency period, and the notice period, and minimum trading of 1 month or 2 months should be permitted for people who want to exit. Though that is a limited point. I think that is the root cause of problem, where you see suddenly stocks going very high and people accumulating stock when they know they have inside information of who's acquiring the business. So that can be prevented.
So I think Anuji, on this point of stopping trading during CRP, this point was discussed. I think for the last 5 years, elaborate discussions have been done with SEBI, exchanges, everyone. Ultimately, and looking at experience from other countries as well, none of the countries of the world's trading stops when entity gets into resolution. In fact, there is an argument to say that trading is all the more important when resolution is going. That's when shareholders must be getting an exit. If I'm facing the threat of either the company getting to liquidation or the company being revived, that's the right time when shareholders should be asked to either decide to exit, sell shares at whatever value they are giving, or to hope for recovery and therefore be invested, stay invested. So exit to shareholders being stopped is almost like you are in a building and the building is, let's say, fire alarm, and that says the gates are locked, so you cannot go out. That would be extremely ironically unfortunate. That point was discussed at length. Like I said, SEBI has been discussing this for almost 4 or 5 years now. So this is it's only during liquidation that trading is suspended. That's the rule in other countries as well. Vikramji is still wanting on the other point of resolution value. I think we are all aligned. Okay, that's what we were saying. Resolution value minus the value of liabilities. The difference is what is paid. I think we'll hear Nitika ji, and then we will maybe move to whoever else.
Yes, sir. Sir, we have a message in the chat box. Mr. Ravi Prakash Ganti has some points. So can we touch upon that?
Can you kindly speak, Ravi Prakash ji?
Yes, sir.
And thereafter Vikram ji, and I think.
Yes, can you hear me?
Of course, we can hear you, sir.
Yeah, thank you. I had basically a very small point. We have been discussing about the fairness, etc. of this proposal, whether it should be there, should not be there, from the angle of various stakeholders. My very limited issue was that this is a session for IPs, and we should concentrate on assuming it becomes law, how we shall implement it, and what are the things that we need to look into from that angle. Why we have different roles in life, but because this is an IPA session, I organize an IPA for IPs. And IPs are not supposed to have views on whether the law is right or wrong. Once we are appointed as the trustee of a company, we are duty bound to implement whatever is the law. So let us assume that if this becomes law, how it affects us, and not get into whether it is right, whether it is wrong, whether it benefits the RA, doesn't benefit the RA, creditor, how are we concerned? I mean, that was my limited issue. That's it.
Ravi, the fair point of it, Prakashji, but as of now, SEBI has sought views on the proposal. It's not the law as yet. SEBI has simply given a proposal. SEBI is asking for feedback. So I think the
Mr. Kothari, I agree with that. I'm not saying no, because SEBI is asking the world at large. Okay. Which includes us individuals, individuals in roles other than as IPs. We can obviously give to SEBI. ICSI could have organized that from that angle. But when it is the IP, let us, I mean, this is my humble suggestion. Let's look at how it will affect us when we are looking at resolution plans. What are the things we need to take into account to assess the, whether it is aligned with it? Because we as RP will have to give an opinion on that. Does it comply with all the laws? This will be one of the laws.
No, fair point. I think once it becomes a law, then I completely.
Then how does it impact us? Let us assume that it becomes the law. Whether it should become the law or not is maybe some of us will be in that discussion too, but that will not be as IPs. Sure. That will be in probably as a advisor to an RA or a creditor, whatever.
Appreciate it. Vikramji, I think if no one else has any other point, then I think Vikramji will be the.
Make quick 2-3 points, sir.
And I think Vikramji will hear you, and then I think I'll pass over to Nitika to maybe make concluding observations. But anybody else who wants to say anything at all apart from Vikramji, kindly raise your hand. And
Bhuvaneshwari, I'm not able to raise my hand. I'm sorry.
Oh, okay. Bhuvaneshwari will just come to you, or maybe Bhuvaneshwari, you can speak first.
Yeah.
Bhuvaneshwari is from Bangalore and a well-known practitioner. Yeah, Bhuvaneshwari.
I just want to make a quick point. I feel, with respect to the resolution plan, approval of the COC, in the past, somebody pointed out already, getting a resolution plan itself is tough. Then the terms are to be agreed by the COC. Third thing, the successful resolution applicant should be able to bring in money and ensure that he complies with the terms, whatever he has agreed. And hence it really becomes a successful resolution plan. When there are so many challenges, one side IBC and the terms and conditions, one side SEBI, I think, how it is working as of today, it has to continue as such instead of bringing the SEBI regulations into IBC and getting it complicated. And as far as the listing is concerned, see, any listing, whether it's in IBC or outside IBC, listing is an individual's choice. Whether he wants to go for listing or not, it is his choice. Same way, under IBC also, whether the new resolution, successful resolution applicant, whether he wants to continue with listing or he wants to delist. If he wants to delist, then he has to comply with the SEBI regulations. I think we have to keep it independent like how it is today, instead of trying to bring in or combine both, merge both, saying that you have to make minimum 25% to the minority shareholders and things like that. I think it's made very complicated. I feel, whatever is there today is very simple. Section 53 is there, Section 30 is there, plus the individual, the COC's rights and the resolution professional, what he can offer, how he can bring in funds. There's so much of complexity already involved. I think we should not make it more and more complex by bringing all other laws into picture. Already the operational criteria, Supreme Court ruling, so much is already going on. And SEBI also bringing everything, then the IBC will become more and more, then we will, instead of moving, going up in the ladder in the IBC execution, I think the reverse trend will set in. That is my view, and I think SEBI and this thing, let us keep it, we need to keep it totally aside.
Mr. Kashi Vishwanathan, you would like to speak further? Mr. Sivaraman? Yes, sir.
I want to say with regard to Ms. Bhuvaneshwari Ramanathan's point of view, I agree to that completely. Because already we are facing a lot of problems. Adding something more to the fuel to the fire, it's not going to serve the purpose. Already you have said, once the plan is being there, the delisting arrangements are not there. Simple. Law is very simple. Let us keep it as simple as that. Rather than bringing in, you have to kind of put this condition, put that condition, then do it. Nobody will come, sir. That is for sure.
Sure.
That's for sure.
Sure. And I think Vikramji was vehemently anyway opposed. So Vikramji would like to add
So
further
2-3
arguments.
points.
Yeah, sure.
First point is, if the company goes into liquidation, then there is a compulsory delisting, right?
Doesn't matter because company
correct. So the company goes into
promulgation of liquidation order automatically leads to.
But what happens if the company is sold as a going concern in liquidation? Do you think that you need to consider that point also in this case? Will the provisions apply for, if the company is sold as a going concern in liquidation? Will these provisions apply or not apply is something, I think needs to be discussed in the discussion paper. That is one point. Second is, how do you ensure that the promoters who are ineligible under 29A do not get hold of the equity, or basically, you ensure that the promoters who are ineligible 29A cannot acquire the shares of the new entity, because that might permit a backdoor entry for the promoters.
That is probably addressed because the offer will be given only to non-promoter public holders, not the promoters.
I think so. It subsequent specifically stated.
I think it's there. It's there in the proposal. But if by market acquisition, the promoters buy the shares, that they can do anyway. I mean, they slowly aggregate shares from the market.
I don't think so it is there in the paper, because my understanding it is not covered in the news, in the discussion paper. And
I think the definition of public probably says it, but kindly go ahead.
Anyway, third point is, do we have similar provisions in other advanced jurisdictions like UK or US, or this is only being considered in India? My understanding is that these provisions don't apply to the other advanced jurisdictions. Are we trying to do something which is not existing in the other countries? You might be more conversant with the provisions in the other countries.
I might only say that in many ways, Indian insolvency law has gone on a different track altogether. It's largely following global principles, but in many ways, it's gone on a completely solo track. For example, question is, do we have an equivalent of Section 29 in any other country?
Correct.
Nowhere else do we have this concept. This is 29A is India's gift to the world at large. Likewise, I'm not sure whether equivalent of this exists in other jurisdictions, but protection to shareholders in a case of delisting, that I think is a basic principle of listing regulations. But I think this is something that I'm guessing.
What Anuj Jain said is extremely important, because how can you distinguish or give protection only to a minority shareholder, and then you exclude the operational creditors, because they are also deeply impacted, or they go through a very deep haircut in the resolution process.
Got it. So I think in terms of views of participants, it's a divided house. There are people who have vehemently opposed and found issues in this concept paper.
And so one more point, is it being presumed that the CD as a standalone will remain as a standalone CD? Or, if the merger happens, then I think it will create further complications.
You're right. That's something that we also mentioned, that if the entity itself undergoes the process of restructuring, there'll be additional problems. You're right on that. So I think, Nitika, we might probably now return to you, and the views, I'm sure you would have kept a note of the views. Different people have expressed different views. I think based on that, we'll probably have to give a feedback to...
Sir, I also have one question, like during the implementation stage, when the monitoring committee is formed and when IP is also a part of it, so how the monitoring committee should also have a watch on this implementation of equity shareholding and public shareholding thing, or IP and the monitoring committee will be excluded from this process? So should this
in my view, after hearing the participants here who rightly pointed out that we cannot keep the process of getting money from minority shareholders and the COC getting that money back as a part of the resolution proceeds. We cannot keep this process connected. That would mean we cannot expect the creditors to wait for money to be collected from minority. And that would be a long drawn process. Therefore, appropriately, the resolution applicant should pay for the entire equity value and thereafter make an offer for sale. So that's an offer for sale done by the resolution applicant by offering shares to the minority as a part of the resolution plan. Therefore, well, if it's a part of resolution plan, then the entire implementation of resolution plan should be overseen by the monitoring committee. And if the RP is a sort of compare of the monitoring committee, should continue to monitor this part as well. That's the way I see it. But there are a lot of details to be, a lot of dots to be connected to make this entire process work. Well, I think with this, Nitika, over to you. And Mr. Rajendran, you want to say something, sir?
Just
How is
one
it?
small,
Yes,
yes, sir. Good evening, fine, sir. Thank you.
Yes.
Sir, one small observation. I just thought that, I have heard the views from all other learned participants in this program. My view is that we have handled 2 or 3 cases of listed companies under this CIRP. And in all the cases, the existing shareholders went high and dry. They didn't get any kind of amount, from the resolution plan as shareholders. In fact, many of them called me and then, they lamented that how come all of a sudden you are just asking me to go without any kind of money and my value is 0 shares. My thought process went like this, sir. The company coming into CIRP is always communicated to the exchanges through a corporate notification, or you say a corporate action, or some kind of information which goes to the bourses, to the stock exchanges. So the shareholders were having an option to exit at any point of time. Today, there is one company under CIRP, as rightly pointed out, even now the trading is happening, whether it is 10 rupees or 15 rupees or 2 rupees, some trading is happening. So it is an informed choice of the shareholders to take a call. It's a risk capital, as mentioned in the note also. The people coming into the equity, they always have back of their mind that their money can, at any point of time, can be swept aside by a tsunami. So having said that, sir, the plan actually is bailing out.
Are we losing you?
Company. So the person bailing out as a white knight should have all. And if am I lost, sir?
Slightly, few words we lost, but you are okay now. Kindly go ahead.
Okay, as a resolution applicant comes to bail out the company, I think he should be given a complete freedom in whatever way, manner, fashion he would like to have the company, even if he wants to have the company as a listed entity. My suggestion to bring back the company into the MPS requirement, minimum public shareholding requirement. And that should be given as a fresh kind of an offer for those shareholders, whether they are minority or even promoter shareholders. It was a decision, conscious decision by them. So they had the options, they had the choice, they had the ability to exit from the company at any point of time. So my thinking goes like that. The law always comes to those who are vigilant and not to those who are sleeping at some point of time, or they are forgetting their rights. So this is my submission, Mr. Vinod, and
No,
I really appreciate the thing.
Thank you. Fairly well made observation, Rajendran. Just that I think on the last part that you mentioned, that the company, if it wants to continue to be a listed company, should comply with minimum public holding norms. I think that's exactly what SEBI is wanting to ensure here, that the company has 2 choices to make, either to stay listed or to become delisted. If it wants to stay listed, in that case, it has to make a minimum public offer. And that minimum public offer must be made to the minority at the same price at which resolution applicant acquired the equity. That's part 2. If the company decides to go the delisting path, in that case, the delisting regulations come back, and therefore the company is to acquire. I think it's largely on those lines only. Of course, with the idea of, you rightly mentioned that equity shareholders always have the choice of either staying invested or to exit the company once the news of, it's not just the promulgation of insolvency. In fact, even an application is filed for CIRP, that also requires immediate disclosure to exchanges. So the information flows to exchanges seamlessly, instantaneously. There's no doubt on that.
Absolutely.
Nitika, I think we have exhausted our time, so we should go back to her and ask her to give her concluding remarks. Nitika, over to you.
Yes, sir. Sir, thank you so much for the session, and thank you for all the participants for joining and for giving their valuable inputs. We will try to collate all the inputs that we have received and we'll send the same to SEBI. And I would request all the participants to individually send your views also to SEBI, so that those views will be seen and maybe a good decision will come from the regulator. So we will share all of your suggestions and we'll send to SEBI. Thank you.
I just want
everybody.
to add that very senior professionals have joined this meeting today.
Yes.
We've heard the views of Mr. Ravichandran, Mr. Rajendran, very Bhuvneshwari madam. A lot of senior professionals have come. So that's very interesting, and thank you all for joining today. Thanks.
Yes, thank you everyone. Thank you.
Thank you, everyone. It was very nice. Thank you.
Thank you.